Supreme Court of India has paused a controversial ruling from Allahabad High Court that stated actions such as grabbing a minor's breast, pulling down the strings of her pyjama, and taking her to an isolated location do not amount to an attempt to commit rape. The Supreme Court, underlining a total lack of sensitivity, expressed its concern over the observations made by Justice Manohar Narayan Mishra in the High Court's judgment delivered on March 17th. However, ironically, the Supreme Court just yesterday had dismissed a plea against this judgment without even hearing it. However, today they have taken suo motu cognizance of the same. The bench, comprising Justice B.R. Gavai and Justice Augustine Masih, stated that they were pained by the remarks and sought responses from both the centre and the Uttar Pradesh government regarding the matter. The court noted that the judgment appears to reflect a serious insensitivity and was delivered 4 months after receiving it, indicating that there was an application of mind. Quote, "We are pained to state that it shows a total lack of sensitivity on the part of the author of the judgment. It was not even at the spur of a moment that was delivered 4 months after resolving the same. Thus, there was application of mind. We are usually hesitant to grant stay at this stage, but since observations in paragraph 21, 24 and 26 is unknown to canons of law, it shows inhuman approach. We stay the observations in said paras," unquote, the court ordered. Solicitor General Tushar Mehta supported the bench's decision, stating that some judgments warrant suspension due to their implications. Justice Gavai remarked on the seriousness of the situation, indicating that such insensitivity from a judge is unacceptable. The judgment of the Allahabad High Court came from a case where a mother had alleged that her minor daughter was given a lift by 2 accused, who then took her to an isolated location where they tried to molest her. Quote, "On the way to her village, they took her to an isolated location under a bridge. They started grabbing her breasts, and an accused named Akash dragged her and tried to take her beneath the culvert and broke the strings of her pyjama." The witnesses Satish and Bhure, who were coming behind on a tractor, reached the spot hearing the cries of the child, and the accused persons threatened him with his life by pointing a country-made pistol to them and fled away, the Allahabad High Court order says. In the same order, it ruled that these actions did not constitute an attempt to rape, suggesting that the prosecution must establish intent beyond mere preparation. In short and simple language, it said that intent of the accused was not clear by their action of whether they were actually going to commit rape or not, and that simply removing her clothes or grabbing her breast did not conclude there any evil intentions. The court then said to file a sexual offence charge under POCSO and not attempted rape. As a part of its ruling, the Supreme Court has issued notices to the Union of India and Uttar Pradesh government while staying specific paragraphs of the Allahabad High Court judgment.